Hello, everyone, and welcome to SCORE Fairfield County's live webinar on managing and growing a one-person consulting business. This is part 2 of our series. Cliff, maybe you could just put the title slide back. The one that following up on the webinar we had a couple of weeks ago, which was actually starting your one-person consulting business. I'm Bob Hogan, the webinar coordinator, business mentor here at SCORE Fairfield County. I'm going to be your host today, and our presenter is Cliff Ennico. More on Cliff in just a minute, but first some brief information on SCORE. SCORE is a nonprofit national partner of the SBA, and locally here in Fairfield County, we have over 100 volunteers, and we offer 3 primary value-added services to small business owners. We offer free one-on-one counseling, and you can access that either face-to-face, via video, telephone, email, whatever works best for you. And to do that, you can use the yellow bit.ly link that you see on the screen, or you can go to our website and click on Request a Mentor. Secondly, we offer a wide range of educational workshops and webinars, including in-person workshops now, and about 100 throughout the year. And lastly, we offer extensive resources on our website, including access to subject matter experts. Our next live webinar will be tomorrow, March 22nd at noon. The topic is government contracting. Are you ready to receive government contracts? With Tanisha Baptiste and Stephen Samaya presenting. And you can find more specifics on our website, fairfieldcounty.score.org. If you're on our website, we also have a large number of recorded webinars that cover a wide range of business topics, and you can access those at any time by clicking on on-demand webinars. Just some logistics about today's event. We have set aside time for Q&A at the end of the presentation. And so Cliff will allow 5 or 10 minutes to do that. And if you have a question, though, please type it in at any time using the Q&A button at the bottom of your screen. Our webinar will end sharply at 1 o'clock to respect your time. The session is being recorded, and the link to the recording will be available on our website, fairfieldcounty.score.org, within the next day or so. It's now my pleasure to introduce our speaker, Cliff Ennico. Cliff is a nationally recognized small business, legal, and tax expert, and is best known as the former host of Money Hunt on PBS, where entrepreneurs defended their business plans before America's toughest panel of experts. An attorney and small business consultant based in Fairfield, Connecticut, he has helped launch over 15,000 businesses. Cliff is the author of 16 books, most recently The Crowdfunding Handbook, How to Raise Capital for Your Business Using Equity Funding Portals. It's now my pleasure to turn it over to Cliff. Cliff, it's all yours.
Hey, thanks, Bob, and very much, and welcome to everybody today. An especially warm welcome to people who attended the first part of this program, which was on March 7th. You people are truly gluttons for punishment, but I really do appreciate your support. I really do. This is a part 2. The first part of our program was on March 7th. We talked about some of the basics of starting a solo practice and more how to market that practice aggressively. That program is on archive. So if you go to the SCORE Fairfield County website, you should be able to listen to that. And like the first session, it was absolutely free. Today, we're going to focus more on what you do after you get up and running. Basically, how do you stay in business? How do you keep clients happy? What are the secrets to success in a consulting practice? Now, Bob did warn you that I am a lawyer by training, although not by temperament. And of course, we always have to have disclaimers. We always have to tell you what we're not going to do before we tell you what you are going to do. Obviously, well, I've been doing programs for SCORE now for 42 years. I guess I was a child prodigy. I was in diapers when I did my first one. And I'll probably be in diapers when I do my last one. But I'm not really a part of the SCORE organization. So anything you hear from me, that's strictly me. You can't hold SCORE accountable for anything. The most important disclaimer is the second one here. We are going to get into some legal and tax stuff today, how to protect yourself against liability, that kind of thing. And there's a very big difference between giving out legal and tax information and giving out legal and tax advice. There's a very big difference between, well, here's what the law is kind of all about, which is what I do. And, now, Bob, here's what you should do. And Jay, here's what you should do differently. And Mary, here's what you should do differently. That's one-on-one advice. And I really can't do that in a program like this. I'd have to get to know you a lot better before I could legally and ethically do it. So if you do hear something that sounds like a good idea and you do it and it doesn't turn out well, your business fails, you end up filing for bankruptcy, your spouse divorces you, you, your kids don't want to talk to you, the dog pees in your leg, and you're living in a diaper box under the Brooklyn Bridge, you cannot sue anybody, okay? That's what this is all about. So let's talk about clients for a minute. I mean, people ask me, what's the most essential thing that you need to have to be a successful consultant? And the answer is a simple one: clients, at least one. Very simple. Something that you do that's a lot of fun but doesn't generate money, we call a hobby. That is not a business. I know the IRS has a very technical definition of hobby versus business, but we're not going to get into that. If you're doing something and it's not making money, that's a hobby until someone is paying you to do it, and that someone is called a client. You can't run a business without them. Although I will say that business would be tons more fun without them. We lawyers actually have a saying that the practice of law would be absolutely fascinating if it weren't for the clients. And we're consultants too, by the way. I mean, just so you know, I mean, call me a lawyer if you wish, but I'm really a consultant. That's really what I am. I mean, I consult to small businesses on their legal and tax issues. That's what I do. That's my particular specialties. Although I kind of bleed, as Bob and any sport counsel will tell you, I tend to bleed toward. I'm not very good at coloring within the lines. If you have a marketing issue, I will certainly be the first to volunteer, and even though I'm totally unqualified to do so. Keep in mind that the clients are your boss, and this is true. This is one of the saddest things about being a consultant, by the way. I mean, let's get this out of the way on the very first slide. Nobody pays you to do stuff that is fun or interesting. Nobody does. The fun stuff is the stuff that they want to do themselves. And my world is no different. People say, oh, it must be fun negotiating deals. No, I don't negotiate the business deals. Most of the time, I don't. The clients want to do that themselves because that's the fun part of doing any kind of a deal. It's putting together the deal, it's structuring it, figuring out how the payments are all going to go, holdback amounts and all that kind of stuff. What do they want the lawyer to do? Draft the bloody documents. That's what they want them to do. Drafting legal documents, folks, is not fun. It is dull. It is boring. It is extremely technical, and you have to get it right. If I make a mistake in my client's document, I could get sued for malpractice. It's a scary thing. When I'm drafting a document for a client, and I do at least one a day for my clients, I've got one hand on my malpractice insurance policy because I'm watching what I do. My wife says that when I'm doing a document, somebody could come in and steal the whole house out from under me, and I would probably not know they were there. And that's just how it is. You have to be that way. Sometimes you disagree with your client's choices. Your client wants to do something and you really feel in your heart of hearts that it's the wrong thing for them to do. That's a very difficult conversation to have with a client. And also sometimes you don't like your clients too. I mean, we'll talk about this a little bit later on. It's not some clients are easier to deal with than others. Some are friendlier than others, but it's a pretty bad idea to let clients become friends. And I'll that may sound a little cynical, but I'll expand more on that later on in the program. Keep in mind, every client is a potential plaintiff in a lawsuit. Keep that in mind. The only person who can sue me for malpractice is my client. I can be as nasty to the other side in a negotiation as I want to be, although I'm usually not. I've learned that sugar is a lot better than vinegar when you're trying to get a deal done. But I always keep in mind that it's only my client. If my client is unhappy about something I'm doing or not doing, that is a much more serious matter because they do have the legal right to sue me for malpractice or make an ethics claim against me or something like that. If you are too nice, but you have to be careful. Everyone is a potential plaintiff in a lawsuit, but if you're too nice to them, they will walk all over you. And again, I'll expand on this. This is the main reason why you let your clients become friends. Friends have privileges that other people do not have, and they also sometimes have benefits, which other people don't have, nor should they. So let's talk about the clients. Well, getting the right type of client is 90% of the battle here. You want clients, but you also want the right clients. In the beginning, it's kind of hard to avoid taking anything, that walks in the door and has a pulse. Sometimes you have to do that because you're starting out and you need money to live on. You can't be, beggars cannot be choosers. But it's not a viable long-term strategy. You can't, as Ricky Nelson once sang, you cannot please everyone in this world, try as you might. There are certain people that just will not get Cliff Ennico, and I've learned to live with that, and that's perfectly fine. They are not on this call, obviously, or maybe they will, and they're going to hang up. But there are some people that you just can't please, and you learn, about that. Actually, you learn about that fairly early early in life. You learn after a while that you can try to attract a certain type of person, and you do. I mean, I hate to take you back. I hate to take you back to high school. I really hate to do that, but it's the best example that I can think of on short notice. I mean, there were certain people that were attracted to you, and there were certain people who, try as you may, you could not get them to respond to you in a million years. When I was in high school, that latter group was called cheerleaders. I mean, I just had no luck getting them interested in Cliff Ennico. Okay. There were other types of people who were attracted to me. And after a while, you learn that that's how you figure out who you are in high school. It's who hangs out with you and who does not hang out with you. Which tribe do you belong to? I could do a whole course on that. What high school teaches you about running a small business, and probably SCORE will ask me to do it, which would be a lot of fun, actually. What kind of people have bought you in the past? Who shares your culture and worldview? Who do you communicate well with? Going back to high school, were you a geek? Were you a jock, or were you an artsy kid? It really boils down to that. I mean, I don't think this has changed, by the way, in the 50 plus years since I was in high school. There are those three tribes in every high school: the geeks, the jocks, and the artsy kids. Some things have changed. The geeks are a lot more popular now than they were when I was in high school. There might be a fourth class out there called the stoners, the ones that are sort of like in and out of things. They just sort of hang around and do nothing. But I've learned, if you really look at them closely, the stoners are almost always geeks or artsy kids. It's very rare for a stoner to be a jock, unless, of course, he's planning to turn professional. So that's kind of like, who do you communicate with? Who signed your yearbook? That means, go back, pull out your high school yearbook and see who signed them, and try to remember who they were. These are the people who definitely are attracted to you, and that you should be trying to attract. We call them natural customers in this world. We talked about that a lot in the last program. What image do you want to project to the world? I mean, you can get rich selling BMWs or Yugos, but you can't, I'm using it, that's an out-of-date example here. I could say you can get rich selling BMWs or Volkswagens, but it's very rare to be able to be successful selling both, because those are two very different marketplaces. Are you doing, $1 million estate planning, or are you doing, people who are in the drunk tank on Saturday nights? I mean, you can make money doing both, but you have to know, what your target market is. Your marketing should be targeted to your desired clients. So if you go to my website at cliffennico.com, if you're looking me up online, by the way, I always go as Cliff. I never go as Clifford. Always search for Cliff Ennico, you'll find a lot. Search for Clifford Ennico, you probably won't find very much. On my website at cliffennico.com, that's the website for my law practice, I say that I am a cost-effective, approachable lawyer for your small business. That is how, notice the words that I use: cost-effective, approachable. I'm not saying that I'm any damn good. Although hopefully you'll agree with me after you've worked with me a little bit. But I say I'm a cost-effective, approachable lawyer. People are scared about paying legal fees. They're also afraid that lawyers are judging them. And maybe, what, you did that? The IRS is coming at, what a stupid jerk you are. That's what they're afraid of. That's how they think we're thinking. Not at all. I mean, you come to me with a problem like that. Oh, good. You have a tax problem? Great. That's what I do. That's like, I can help you with that. Come on in. We'll try to address this, and don't worry. You probably won't spend too much time in an orange juice, so don't worry about that. That's what I'll try to do. Keep in mind too that on social media, especially, I know a lot of younger people are very fond of social media. I am personally not a big social media person. My Facebook page will not excite anyone, although I do have a pretty damn good LinkedIn profile. We'll talk more about that maybe a little bit later. People judge you by the company you keep. If I look you up on LinkedIn and I see you're surrounded by a bunch of yahoos, I'm going to think that you are a yahoo too. It's the way human beings think. It's just how we are. It's human nature. The best clients to have are those who pay on time, cooperate, and are easy to work with, and will help you build your business via referrals. That's the sweet spot. Those are the people that you're really looking for. Okay, some clients you don't want. And by the way, there is no law that says you have to take every client that comes in the door. People think, well, you're a lawyer, you have to work with. No, that's not the case. I can turn down business ethically. That is not a problem. Here, the main client you don't want is somebody who doesn't know what they're doing and have no money. Notice the and. A lot of my clients don't know what they're doing, but they have money, and that's okay. A lot of my clients know extremely well what they're doing, and they don't have a lot of money, and I try to work with those people. That's why I work alone. I don't have a staff. I don't have partners. I don't have a law firm. I did this deliberately because I wanted to be able to offer those kind of people a terrific deal. A drop-dead entrepreneur with a great idea but has the social skills of a capuchin monkey. Those are the kinds of people that tend to attract themselves to Cliff and Ennico. That says a lot about me, I think, too. But when that and comes into play, if they don't know what they're doing and have any money, you have to sort of get them out of your life. They are a huge underserved demographic. There's a lot of these people out there, especially here in the Northeast. There's a lot of them. There are a lot of people laid off from corporations who think they know a lot about running a business, but all they've ever done is spreadsheets for a large corporation for 35 years. And really, your average high school kid knows more about entrepreneurship than they do. You have to be prepared for that. There's a lot of people out there who, what does Socrates say in one of his things? He knows not, but he knows not that he knows not. There's a lot of people like that out there. Some clients you don't want, deadbeats. Don't pay. The surest way to turn Cliff Ennico off is to be late paying my bill. If I have a problem with you with a bill, we're dead. We're over. We're done. I'm sorry. You may be a great guy. I'll love you. Maybe I'll try to refer you to someone else. But if you can't afford to pay my extremely reasonable fees, I really can't afford to deal with you. I'm not doing this for my health. Trust me. Pugilists, people who always fight you back. They argue over everything. I don't want that. That's my job, is to argue for them. I don't want people arguing back at me. Phantoms, you call them, they send you $100 check and they disappear for 5 months. You send them email after email after email. You don't hear. And then the day before you leave on a 3-week vacation, a Mediterranean cruise, they call you with something that needs to be done tomorrow. Those are the people you don't want. Time vampires, people who eat up the clock and who suck all the time out of your life. And it's very hard. Some of them are very nice people. I find that nonprofit organizations tend to be incredible time vampires. And I love them. Sometimes I agree with their mission. Sometimes I don't. But the problem is they're very nice people. It's hard to say no to these people. And they're the ones that want me to pull all-nighters because they just don't have their act together and they need me to be the organized one on the team. Do-it-yourselfers, those who are just looking for me to train them to do something so that every once in a while, I'll do a deal and the client will say, hey, look, can you just do me a favor, Cliff? Can you just take the names out and just send that to me? I'd like to keep this as a template for the future. What is this guy doing? He's going to use my form for other deals, right? He's taking money out of my pocket by doing that. Well, I'll be nice about it, but I'm going to say, no, I'd rather not do that. Let's see what comes down the road first, and then we'll see what to do. Do-it-yourselfers are a problem. Litigators, these, again, people, if you think of someone as being a walking malpractice case, they probably are. Keep in mind, your gut is often smarter than your brain in a lot of ways. If a client smells off, especially the last group, the litigators, the ones who might be a potential plaintiff in a lawsuit. If I really sense that someone is a walking malpractice case, I do not take on the matter. I don't want that person in my life. And I don't care. And here's how I tell them, by the way. They always come on the same way. They say, Cliff, I've used a couple of lawyers in the past, but frankly, they were a bunch of idiots. I've seen some of your videos. I've seen some of your YouTube things. I think you're the guy I really want to work with here. You're not like those other attorneys. I know right off that's a screaming red flag for me. I'm saying, okay, yes, maybe you've had a problem with one attorney. Not every attorney out there is a Cliff Ennico, Lord knows. Maybe that's a good thing. But when you've had problems with 4 or 5 attorneys, I'm sorry, that's not the attorney's fault. That's you. You're a problem, and I don't want you in my world. So if a client smells off, send them elsewhere, preferably to your competition. I actually keep a list of attorneys here in Connecticut that I consider to be my chief competitors, and whenever I come find a person like this, I give them their names. I figure let them have the time vampire, the phantom, the do-it-yourself. Let them deal with that odd shit. I'm out of here. I'm too old for this crap. Okay, so now let's talk about how to deal with your clients. Let's talk about your consulting contracts. We're going to spend some time here. This is what I spend a lot of my time doing for clients. Just so you know, I represent over 250 consultants in virtually every state of the union. I do a lot of consulting contracts. Hardly a day goes by that I'm not reviewing or drafting a consulting contract for one of my consulting clients. So this is my A area of expertise here. Generally speaking, if your clients are much larger than you, they're not expecting you to have an agreement of your own. They have their own agreement. It's usually a monster. It's a 50-plus page master services agreement is what they call it, an MSA with statements of work for each job that you do. And it's like 50 pages long, and it's all legalese. They want you to comply with 50,000 federal statutes that you've never even heard of, that kind of thing. Generally speaking, that's it. You need someone to review that for you. Unless you are in the business of looking at 50-page contracts like me, it's very hard to tell what's important and not in those things. I have a deal with my clients right now that if you're in a situation like that, send me the contract. I'll look at it. We'll talk about it over the phone. We'll figure out where you have to push back and what you can live with. And I do with that for a flat fee of $500, just so you know. And I'm not just advertising my services here. I want to give you a sense too of what a reasonable legal fee would be to have somebody else review this for you. To have it, especially if you're not familiar. Once you get familiar with these contracts, then you don't really need to go to the attorney every time you get a new one. But those first couple, you're on a learning curve. So take the time and then learn from the pros. What's important, what isn't. That clause there about the equal opportunity, you don't have to worry about that. You're a solo, you don't have to worry about that. But that thing over there about where they take the lien on your firstborn child if you default, that's something I think you want to push back on. Those are the kind of conversations you should have with your attorney. Now, let's say your clients are not big companies. Let's say they're small or mid-sized clients. They don't have a form of consulting agreement. They will need your own suite of consulting contracts. And there are 4 things you need to have in your arsenal. Okay, if you're dealing with these kind of clients, you need a standard confidentiality and non-disclosure agreement. I prefer that be a mutual non-disclosure agreement where you agree to keep their stuff confidential, they agree to keep your stuff confidential. I always go for it with, some people call it a bilateral non-disclosure. I call it a mutual non-disclosure. It should go both ways. It shouldn't be one-sided. A short form consulting agreement, no more than like 2 or 3 pages, because the minute you get longer than that, the client will go screaming to their attorney, and now you have a legal discussion going on. Your attorney and their attorney are playing the 2 scorpions in a jar, that kind of thing. You don't want that. A subcontractor agreement. Right before I got on this call, I got a call from one of my consulting clients that he normally is the prime consultant on a job, but now someone wants him to be a subcontractor on a job, so he needs a form of subcontractor agreement. That's the agreement between you. Let's say, for example, a client hires you to do a job. You can do 90% of it, but you have to outsource the other 10% to someone. This is the agreement that you would have with the 10% person. Last but not least is the statement of work. Now, that is a very useful document because it's not a legal document. It's like a term sheet for a deal. It's a short document that basically spells out all the variables, the things that change from one client to another. When I do a consulting agreement for a client, there's 2 parts to it. There's the statement of work, which is just the business stuff. What are the services? What are the deliverables? What's not going to be done? We'll talk about that in a minute. And then you have the legal contract, which is like a wrapper for the statement of work. The statement of work is Exhibit A to the legal contract. You want to try to keep these things separate. A lot of people get confused when they try to do these themselves because they get the business stuff and the legal stuff all mixed up. Just keep the legal stuff separate, and then it's just here are the legal terms that apply to everything that we're going to do, and then the statement of work says everything you're going to do. That's a very useful way to keep sane when you're doing these. Let's talk about the statement of work. Only the business stuff, no legalese. There should never be legal terms in a statement of work. A description of the services to be provided, the timetable for completion with milestones if you're doing it that way. Each project has a milestone. When you reach a milestone, you get paid. A list of deliverables, if any of their specific things like a report or something, or a PowerPoint or something if you're producing some creative content for the client, a list of those. The client's responsibilities, I always throw a term in my statements of work that says that the client will respond to all phone calls and emails within 48 hours. Remember the phantoms, the people that disappear. This is how you learn to deal with them. If they don't respond in timely fashion, then you can shut them down, you can terminate them. A list of subcontractors, if any, locations where the services, are you working on their premises? Are they, are you working out of your home office? And then special terms and conditions. Whenever you deviate from the legal terms in the consulting agreement, this is the place to do it. The governing law will be New Jersey, not Connecticut. That kind of stuff. Every once in a while, a client will ask you to change something. It's best to do it in the statement of work, because the minute you change it on your form of consulting agreement, you will forget to change it back when you take on your next client. And that becomes a problem. So now all your contracts are governed by New Jersey law, which you don't want if you're based in Connecticut. Let's talk about the consulting contract here. Okay, now let's talk about the legal contract. Okay, there are 4 things that have to be in this contract. Because what services will you perform? Well, that's in the statement of work. How do I get out of this thing if the client turns out to be a jerk? Okay. I mean, every, a contract has a clause that says this agreement will be for a term of 1 year unless terminated by either party upon 90 days prior written notice. I want to know, how does this thing, because let's face it, remember I said before, no one calls their lawyer when they're having a nice day. Okay, no one, people do not pay you to do things that are fun or interesting. As long as everything goes well and you and the client communicate well, I'm never going to get a phone call from you. When I'm going to get a phone call from you is when the what has hit the fan and you're not happy and you want to get out of this. Say, Cliff, this client is a mother. He's exactly the kind of person that you warned me about. How the hell do I get this person out of my life? That's when the termination clause becomes incredibly important. I want to see a clause. And I'm very open. Some people want to lock their clients in, but I think that's a very bad idea, because by locking them in, you're locking yourself in too. Clients that are automatically renewed, for example, where if you want to get out of the contract, you have to give me a notice at least within 30 and 60 days prior to the end of the existing term. Otherwise, it renews automatically for another year. Beware of those kinds of clients, because no one remembers that window of termination. Nobody remembers that you have not later than 30 nor more than 60 days prior to the 1 year anniversary. No one can do that unless you have a 10-year contract, 10-year calendar on your phone or something like that. It's very hard to keep track of those dates. I like to see very simple language. Either party can terminate. If somebody's not happy, either party can terminate upon 30 days prior written notice. That's it. That way, if the person turns out to be, the devil incarnate, it's only a 30-day problem at that point. You just got to give him notice, finish whatever it is you were doing, and get this person out of your life. Maybe give him some of his money back or something and get rid of him. How much will you be paid? That's usually not a problem. Just about every statement of work specifies what the hourly rate is, whatever. But here's the thing, and this really bugs me, and I've seen some consulting agreements drafted by some of the top law firms in the country, which are vague on this point. And that is, when will payment be due? I would say that half of the consulting contracts that I review from my clients, that other people prepare, are very good at describing the services. The termination clause is pretty clear, the amount that's going to be paid. But when it comes to saying when payment is due, all of a sudden things get fuzzy. Payment will be due upon delivery of the following 3 things to the customer's satisfaction. All right. When do you get paid? Okay, you get paid when the customer is satisfied. Those of you who design websites for a living, when is a website ever finished? When is a website ever completed? Answer, it's never completed. There's always additional things that need to be done. And it's very hard to get to the point where the client says, okay, yep, I think I'm satisfied now. I got what I need. Here's your money. It's very hard to do. I like to see very bright lines when it comes to this sort of thing. I want to know, when can my client sue? When can I send a nasty, threatening letter to the customer saying, hey, hey, Jacko, pay up? When can I do that? If the agreement is fuzzy on that point, I cannot legally send a demand letter for a debt that's not due. I mean, I could be sued I could be brought up on an ethics charge for that, for launching a frivolous threatening a frivolous lawsuit. Believe it or not, I get in trouble if I do that. So here's some advice. X days after invoice, yes. Yes, specific date. No, upon completion, upon client satisfaction, upon clients of acceptance of delivery. The minute you see language like that in a consulting agreement that you're being asked to sign, you have to push back on that a little bit, because otherwise you are going to, you are opening the door to a potential payment dispute down the road, and you don't always have the right to shut down services and work it out with the client. You may have to work for free for a while, if you don't get this right. So be prepared. Other trouble spots in the contracts, a lot of people like to do non-competes and non-solicit. Cliff Ennico's rule number 1, never sign a non-disclosure agreement with a client or potential client without reading the damn thing first. A lot of people say, oh, it's an NDA, they're standard, they're boilerplate, you can get them online at uslegalforms.com or something like that. Never, ever do this, because I know a lot of companies, a lot of clients, and sometimes even the big boys, the big clients, will sneak in non-compete or non-solicitation language, restricting who you can do business with once you sign the agreement. So for example, what they usually do is they disguise it as a conflict of interest provision. Look for that language. Whenever you see conflict of interest that says you will not engage with, as long as this agreement is in effect, we will not, you will not do, work with any other person if such would pose a conflict of interest with your obligations under this contract. What does that mean? That's a non-compete, folks. That's exactly what it means. It says you cannot work with anyone that client does not like. And since this is just a non-disclosure agreement, you haven't been paid yet. There's no contract yet. You should never have to, if you're not being paid for something, you should never agree to a non-compete or a non-solicitation agreement. That's an agreement that's not a non-compete. A non-compete says thou shalt not work for another company that competes with us in the same industry. A non-solicit is a clause that says we can work with anybody, but we will not solicit any of your customers for a period of time. We won't try to handle business away from your customers. Very important, by the way, in subcontractor agreements, because your subcontractor, what always happens in subcontractor agreements, the client likes the subcontractor better than they like you. Okay, that's what happens. And so they start dealing with the subcontractor behind your back. There's very specific language that you put in subcontractor agreements to prevent that from happening. We call it non-circumvention language. That's the technical legal term, but basically it's a don't steal my client's clause. Okay, think of it that way. Assignment of rights and work. Sometimes it's called assignments of work product. Okay, this is one of my big things. Every consulting agreement has it. It's a clause that says that anything you create for me, I own it. I own the copyright. I can make changes to it. I can do whatever I want to do. That's okay, but only when you are paid in full. That's a change. Whenever I see a clause like that, I always say, upon consultant's receipt of payment in full, client gets all the IP rights and intellectual property rights and all that stuff. Make sure to exclude tools, templates, and materials. So for example, if I'm doing a program for SCORE, and I take up my previous program and I just tweak it a little bit and make a few changes to it. Okay, SCORE has every right to take this program and they can do what they want with it. They don't owe me a nickel for it. I'm happy to do it for nothing. But I can take this program and I can use it in some other way. I'm not prevented from doing that, which is what happens when you assign somebody the copyright. If SCORE owns the copyright, then they can change this program. They can give it to somebody else, have them present it. I don't want them to have the right to do that. So exclude tools, templates, and materials from the stuff that they have their intellectual property, and then specifically exclude work product that's created for other clients. So if you do take their template, if you do take their thing and use it as a template for another customer, that is, that's okay. In other words, it's not exactly the same thing that they paid you for, but you do have the right to do that. As an independent contractor, legally, you must have the right to work for other clients. They cannot say that you can't work for anybody else. That's an employment relationship, if that's the case. That's the key difference between being an employee and being an independent contractor. They can control, if the person can control who you work for, when you're not working for them, that's an employment relationship. That's not independent. We covered that in the last section, by the way, the whole employee versus independent contractor thing. Managing client expectations. If there's one thing I've learned in 42 years of working with clients, it's all about communication. Clients hate surprises, especially regarding fees. If you get nothing else out of this program, ladies and gentlemen, I want you to get this one. One of the surest ways to get a client angry with you, probably the most effective way to really get a client's blood boiling, is to send them a bill that they're not expecting. Okay, I over communicate fees. Some people are very reluctant to discuss fees with lawyers. They're very nervous about that, but I encourage it. I open myself to them. I said, look, you need to know, and I need to know too. If you cannot afford to pay me $10,000 for this job, I want to know about that now. I don't want that to be a surprise later on, because then we both have a problem. You have a bill you can't pay, and I have a bill I can't collect, and that's a problem for both of us. And there's no effective way of solving that problem. There's small claims court, but forget small claims court. Clients hate surprises. If you've estimated how much something is going to cost and you feel you have to go over that, tell the client before you do the additional work. Don't just do the work and hit them with a surprise bill. Well, I know I said it was going to be 1,000, but it's really going to be 2,000 because of X, Y, and Z. Clients hate when you do that. Tell them upfront, you know what? I know I said it was going to be $1,000, but we had this lien on your assets. We had to spend some time getting that thing cleared because the bank wouldn't respond and yada, yada. Just so you know, I had to spend a couple of extra hours on that. It's probably going to be more like 1,500. Is that okay? Those are the kind of conversations I have with my clients all the time. Email, by the way, is a wonderful tool for this. I'm not a big fan. Well, let's put it this way. Most lawyers are not fans of email in general because of some of the ethical issues they can create. But this is a great way to communicate fees to a client. Hey, Joe, just to let you know, well, wait a minute, you never told me it was going to be an extra. No, I sent you an email 2 weeks ago. Did you see that? If you didn't look at it, I'm sorry, but I did tell you this was going to be an extra $500. There's the evidence right there. It's a very useful thing. Whenever always get the client's buy-in to a difficult decision. Sometimes you need to tell them something that they don't want to hear. Remember, I said sometimes you don't always agree with what your clients want to do. If you're not, always get the client's buy-in to a difficult decision. Get them to agree to it and then document it in an email. Just to let you know, I know you said about, just so you know, I did warn you about that lien on the firstborn child clause and the thing, I understand that you don't really care. You don't really like your kid anywhere. You're just as happy to have the client take them if something goes wrong. But I just want to make sure we're clear. I did tell you about this. I did warn you about the consequences about this. Are you okay with that? Yes. Okay. That email address gets printed out and goes into a file because sure as hell, sure as shooting, if something goes wrong and they take the kid, they're going to come back screaming at me. Why didn't you tell me about this? And I want to have that evidence right there. I did tell you about this. You just overruled me, which is fine. You can overrule me, but then you're responsible for the consequences of that decision, not me. Okay, if you're not sure what the client wants, and every once in a while clients, they don't know themselves sometimes what they want. They're counting on you to guide them. More fools they. Give them a range of options and let them guide you in the right direction. I find that if I throw a client a menu of options, sooner or later, by their body language, the way they use their voice, I'll be able to figure out that they really are favoring one of these solutions over the other, and then I will gently try to push them in that direction. I think it was Franklin Delano Roosevelt who said, leadership is 90% of the time figuring out which way the crowd wants to go and then get in front of them and start waving a flag. I think that was one of his exact words, but it's words to that effect. In other words, you don't tell people what to do. You see where they're going, and then you get out ahead of them to show them which way to go. And this is a good example of that in practice. When a client refuses to follow your advice, and that happens a lot in my world, get it in writing. Print out the email and put it in a file folder. I cannot tell you how much time this has saved my life. When a client calls me 3 years later and says, hey, Cliff, you really screwed up here. You did this and you really shouldn't have done that, yada, 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 and I know that I did discuss this with the client, but the client wanted to go ahead with the deal anyway. I told him it wasn't such a good idea to do the deal, but he did anyway. I want to have that email in my hands within 5 minutes. I don't want to have to go wade through 50,000 email threads on Gmail to find this one smoking gun. I want that in my hands in 5 minutes so I can scan it, send it to the client and say, look, sorry, Joe, but this one's on you. This one's not on me. I warned you about that, and that's going to be my defense if you come after me. Okay, return client calls and emails as promptly as possible within reason. I mean, let's face it, we all have to live our lives. I actually have an excellent, I mentioned a couple of times, I actually have a YouTube channel. For those of you, this program right now is not available on my YouTube channel, but we'll see, I may put it up there. Right now, I've got over 50 one-hour video presentations. Most of these were score presentations that I've done over the past 40 years. Some of them are getting kind of old, but most of them are still pretty good. If you search for Cliff Ennico on youtube.com, you'll see all the YouTube videos that I've done. If you search for Cliff Ennico Time Management, you'll see that I have a one-hour program. It's really meant for lawyers, but consultants would benefit a lot from it as well on how to manage your time. I talk about such specific things as email inbox and how to manage that and all that kind of stuff. It's got a lot of ratings. It's been viewed by about 50, 60,000 people so far. So I must be onto something. No one has said I'm full of it. So I must be doing something right. And these are all free, by the way. These are one-hour videos. Check out my YouTube channel at some point. Okay, I said it before, and now I'm going to explain why. It's okay to be friendly when you communicate with clients. I mean, let's face it, people are a little intimidated by lawyers, so I go out of my way to try to be approachable when I talk to people, but you need to maintain a professional distance. When they become too friendly, that is not a good idea. Friends can impose on one another. They frequently do. Hey, Joe, listen, I'm moving my apartment. Can you help me move a couple of sofas? I mean, friends have the right to do that. Friends can borrow money from each other, and sometimes they don't get paid because, hey, they're friends. Friends do stuff for each other for free. Clients, you don't do any of these three things with clients, ever. If you find yourself getting too close emotionally to a client, especially romantically, and I mean, let's face it, I've been happily married now for 37 years, but let's face it, if you're younger, you're just getting started, you're still in the dating pool, it may well be that you find yourself falling for one of your clients. Romantically, it's very difficult to be objective when you're in love with a client. It's very hard to give them. I mean, every once in a while, you got to tell your client that they're being an asshole about something. Forgive my language, but you have to do that sometimes. It's very hard to do that when you're in love with somebody. So consider getting somebody else to work with them if that's the situation. And congratulations, by the way, if you find yourself in that situation. That's true. When clients are dissatisfied, okay, so now let's talk about when the relationship sours. Okay, the customer is always right. Those of us in Connecticut, we have a grocery chain called Stu Leonard's. It's a local, regional grocery chain. They have about a dozen stores here in Connecticut and southern New England. And in front of every store, there's a gigantic granite boulder that says the 2 rules of customer service. Rule number 1, the customer is always right. Rule number 2, if the customer is ever wrong, reread rule number 1. And I love that. And I hope you don't mind I'm giving them a free plug by doing that, but it's just, that is so perfect a way of putting it. The client is always right. The minute a client, you have a fight, you will never win a fight with a client. You will never win a fight. Your job is to avoid fights whenever possible. Okay. Whenever you argue with a client, you ultimately lose. Even if the client pays you, it says, okay, screw it, Cliff, I'll pay you the extra $10. I'm sorry, I don't think you earned it, but you have just lost that client. They're looking for another attorney. They're looking for another consultant when that happens. And maybe you want that to happen. But it's not the way you ultimately want to part company. What do they say in all the cartoon series? Don't go away mad, just go away. Don't cower and hide. Address the situation quickly, honestly. If it was your fault, offer to make it right, although don't admit liability. We'll talk about that in a minute. Offer to make things right. Saying, well, I'm sorry you feel that way. Tell you what, I'll take an hour off my bill. I'm sorry. I thought it was a little bit of a surprise. I'm sorry I didn't get a chance to tell you about it, that there was this little thing, but don't worry. The relationship's more important to me. I'll get you next time. Have backup for anything you tell your client in support of your position. Well, wait a minute, Joe, you did tell me that, you wanted to proceed in this direction. I didn't think it was such a great idea, but have the evidence right there. Send him the email, say, just let you know, look at this email exchange. This is where I told you this could happen, if you did it that way. Consider a free reduction and never charge for correcting a problem if it truly was your fault. In fact, I'll tell you something. Here's a little trick that I've learned about billing. Let's say that I'm in a situation where I did, in fact, do too much work. I said to him, I said, you know what, this is not right. I mean, I told the client that it would be up to $5,000, but $4,000 is a pretty big bill for this. I don't really want to bill that. It's going to be a fight, and I'd rather avoid the fight. Here's what you do. Don't bill. Let's say, for example, you think that the reasonable bill is $3,000 as opposed to $4,000. Don't just send a bill for $3,000. Send a bill for $4,000, but then write off the $1,000 on the bill as a client courtesy, and with the net of being $3,000. I find that when I do it this way, there's never a fight with the client. The client thinks that they're getting a deal, which is a good thing. They like you. They like you for giving them that deal. Maybe they felt that you did a little too much work, but you're kind of acknowledging it. Yeah, I did a little too much here. I can't justify a lot of what I did here. So here's, rather than fight with you, let me just give you the courtesy right now. We'll be done with it. And in fact, I'm probably still doing pretty well with the $3,000 that I'm getting. But the point is that by doing it that way, by showing it to the client, making it visible, you are increasing the good vibes that the client has about you. Well, this is an honest person. Most attorneys don't do that. They don't write off time unless you ask them to. The fact that this is a very ethical guy, if this is what he's doing. That's the image that I want to have with clients. And it is true. I mean, I will never send a client a bill if I myself think it's unreasonable. But although there's a flip side to that, which I'll tell you in a minute. But don't admit liability, especially in writing or in an email, without first consulting your lawyer, or if you have insurance, your errors and omissions insurance coverage. Don't be very careful about this. No, I mean, let's face it, if you do, God forbid, get sued for malpractice or negligence or whatever, professional liability, you want to make sure that that insurance policy is going to be there to protect you. And if there's a smoking gun email where you admitted, yeah, I really screwed up here, this was my bad, they are not going to like that at all. And they will find ways to try to wiggle out of the policy. So just never admit anything, especially in writing or in email. Say, you know, I'll give you a concession. I see you're unhappy, and I think the relationship here is more important to me than anything else. I'll definitely give you a concession, but you know, I'm not admitting wrongdoing here. I'm not going to say that I did something wrong here. You know, if there's a problem with an invoice, deal with it before you send. Again, never send a client an invoice that they are not expecting. The flip side, by the way, and maybe some of you may think I'm too cynical here, but you know, how do you know if you're not billing enough? Okay, here is Cliff Ennico's rule of thumb. This is not the law. It's just what I use as a rule of thumb. If none of your clients are questioning your fee quote, if absolutely none of your clients have a problem with it, you give them a quote, it's going to be $2,000. Okay, great. If that's what's happening all the time, you're not charging enough. That sounds so cynical, but it is really true. If people are not at least questioning how much you're charging, wait, $5,000 is a lot of money. You know, what are you doing? Why is it so high? I don't get that. Why is it going to be like 10 plus hours of your time? You know, that's fine. That's an okay discussion to have. But it's if no one's asking that question, chances are you're making it too easy for them to say yes. You're probably too far below the competition, which is why they're not saying anything. This is a great deal. I'm getting Cliff Ennico for this. You know, I'm not going to question that. Okay, Cliff, that's fine. Let's move forward. Again, that's human nature. Okay, what happens when a client posts a negative review online? It happens to even the best of us. Remember, there's an old Spanish saying, revenge is a dish best served cold. Stay cool. Do not overreact. Okay. An emotional response, especially online in a social media forum, will do you incredible damage. Wait 24 to 48 hours. There's no law that says you have to respond to a negative review immediately. Give it 24, 40 hours. You know, think about how you want to respond to this. If the review demonstrates that the client is a raving lunatic, now you've seen this. Now there's this website called nextdoor.com. I don't know if you're familiar with it. If you're not, it's basically neighbors talking to their neighbors. It's limited to a certain set of zip codes, and people say, "Hey, I've got this old refrigerator. Does anybody want it? Just take it off my property, and it's yours. We found this lost cat. Is anybody looking for a lost cat?" This is the kind of stuff. It's all over what used to be the neighbor fence is now nextdoor.com, and there are some really wacky people on nextdoor.com. I mean, they post bad things that happen to them, you know, some local store or something like that. Generally, you can usually tell by reading these things if someone is a raving lunatic or not, or just, you know, is off their meds or something like that. The best response may be no response at all, because by responding, you are legitimizing this tirade. The best response is, you know, if it clearly is someone who had a legitimate gripe, just simply saying, "I'm sorry you're here. We are not satisfied with my services. Please contact me offline. I'll do whatever I can to make things right." That's always the best answer. You know, you're not admitting liability. You're just saying, "I'm sorry you weren't happy." Sometimes I will throw in, "This is the first I've heard that you were upset with my services." That's a good thing to do, because what it does is it sends the signal, wait a minute, this person didn't even try to talk to Cliff. He just went online and ranted about him. This is a jerk. Okay. And I want people thinking that. I want people thinking the person that posted this is a jerk. Do not get into an online argument with a reviewer or get overly defensive. Even if you're right, you will scare off potential new clients. Oh, God, this guy's vicious, man. He fights. Okay, I mean, I understand this person might have had a legitimate gripe, but he was all over her, was calling her an idiot and all this kind of stuff. Ooh, I don't want this guy. I don't want him. Always ask satisfied clients to post positive reviews so that they will outweigh the occasional negative. People don't do this enough, especially lawyers don't do this enough. I always say, if you sometimes say, "If you were really great, I really appreciate that you saved my deal, you know, whatever, could you please say a few words on your social media about that?" You know, I want people to see, if there is a negative review, I want them to see 10,000 positive reviews. That more than overweighs the occasional negative. Okay, going back to billing strategies. Bill early and often. I mean, I can't imagine, lawyers are especially prone to this. We get so involved in the projects that we're working on from time to time that we sometimes forget to send bills out to our clients. We let things go 3, 4, 5 months, and then we have a huge bill now that needs to be paid. And that's a tough sell to a client. People are much more likely to pay frequent small bills than a single massive one, even though it's justified, even though you can justify every minute that's in there. I used to have a landscaper that did this. They did a good job. He was a great landscaper, mowed my lawn every week. And I begged him, send me a bill, send me a bill. How much is it roughly? I'll send you a check right now. Don't, but he refused to do it. What he did was in December, right before Christmas, he would send bills out to all his clients for services rendered, ... And he billed for the entire year, $15,000, $20,000 in one bill. And the bill was payable upon receipt. A week before Christmas, you get a bill for $18,000 that has to be paid immediately. I could not, after 2 years of working with this guy, I said, screw it. He's a great landscaper, but I need to pay bills every month. And if he's not willing to do that, then I'm going somewhere else. I fired him. I had to. I just couldn't work with him that way. Always, always, always try to get some money up front, especially if the client is one that has never dealt with one of your tribe before. If he's never not used to working with consultants, this is not a friendly thing. This is not someone who, I'm not just helping you over the garden fence here. I expect to get paid. Let's get the client used to the idea that they have to pay for their services. Always send detailed bills showing the client how much hard work you did for them. I never send a bill for services rendered ... $5,000 unless a client tells me specifically it's okay to do it that way. That never happens. I always send a bill saying on thus and such a day, here's how much time I spent and here's what I did. On this, the next day I did this and this. I always let them see, because that gives them less wiggle room to say that my bill is unreasonable. Also, too, it's a good exercise for me to sort of go through this and wait a minute, I did spend 2 hours on that. I should not have spent 2 hours doing that. I'm only going to bill for an hour. It gives you the chance to reality check your timesheets and see, if the bill is one that's likely to be questioned. It flags that. And then I know I have to have a conversation. By the way, just to let you know, I did say it was going to be 2,000. I'm just going to warn you the bill's going to be more like 2,500. And here's why. Again, communication is the key to a successful client relationship. If you did spend too much time on a project, give the client a courtesy reduction, like I told you to do before. Bill the whole amount, but then give the excess as a courtesy to show them, hey, I know this was a little bit too much, but don't worry. I don't expect you to pay it. What you get in client goodwill is far more valuable than the $1,000 or $2,000 you had to give up by doing that. Bill the most amount of time on the activities clients find most distasteful. Remember I said clients don't pay you to do the fun stuff. Remind them of all the awful, icky, I had to pull an all-nighter to do this 300, look at this 300-page contract. Let them know how you suffered on their behalf. Remind them of this. And they'll be less likely to question your bill. And for younger clients, send bills both by email and snail mail. I had a client a couple of years ago. He was a 20-something, genius. He was doing he's starting up a big data company. He lived in an apartment in New York City. And, back then, I didn't always send copies of bills by email. I sent snail mail bills, right? Well, he ended up owing me like 3 months, and this was getting too much. So I said, I called him up and I said, Mike, hey, just to let you know, I've sent you 3 bills. You haven't responded to any of them lately. What's going on? He goes, Cliff, you've never billed me. Really? I've sent you 3 bills. He said, I said, well, wait, well, I never got, an email or a text from you. He said, no, I sent them snail mail. Snail mail? I said, yeah. He goes, wait a minute, let me call you back in an hour. This guy did not know there was a mailbox in the lobby of his building where snail mail accumulates. This was he was about maybe 25 years old, this guy. He did not know that there was a place where snail mail in his building. And when he did, he goes, Cliff, I apologize. I said, I did, you're going to laugh, but I didn't realize that there's a mailbox in my building. I got all 3 of your bills. I'll pay them immediately. Please, would you do me a favor in future? Would you send me a text? This is, the kind of, if you're dealing with younger clients, they don't know that physical pieces of paper even exist anymore. You have to reach them electronically the way they want to be. Okay. I could do a whole program on dealing with deadbeats. In fact, I have. It's on YouTube. If you search for Cliff Ennico dealing with deadbeats, it's a whole hour on how to deal with this. I'm just going to give you an executive summary. There are 6 steps involved in collecting overdue bills. Stop working the minute a bill becomes overdue. Big receivables almost always start out as small ones that get out of control. Okay, almost immediately. Don't keep working if a client is not paying you. You know, that guy that I just talked about, the guy that didn't know he had a mailbox in his building, you know, the bills were very small, so I didn't care about it. That's why I kind of let them accumulate. Normally, if these were bigger bills, I would not have. I would have called them on day 31 saying, hey, where's my money? Contact the client immediately, friendly, don't too much. Just, by the way, just let you know my bill's a little bit overdue now. What's going on? Give me a call. You know, if you need an accommodation, let's talk about it. But I'm not going to work for nothing. Try to negotiate a solution, either a payment schedule, fee reduction. Get it in writing. Always get it in writing. You know, document this, saying, okay, you know, and put in the language, time is of the essence for each payment. So, okay, you can't pay me up, but you can pay me over 3 months. Okay, that's fine. Each payment, $1,000 a month. I'll take that. But time is of the essence with each payment. If any of these installments is even a day late, I'm shutting down. Okay. If the client stonewalls, have your attorney send a formal demand letter. You must make a formal demand for payment in order to enforce a debt. That's the law in just about every state that I'm aware of. But don't do it yourself. Have your attorney do it, because it's much more credible. When the client sees that you have lawyered up and they're no longer dealing with you, they're dealing with somebody like me, you know, who will not budge, you know, who cannot be persuaded to do anything, they're much more likely to come to the table and saying, listen, I really got a problem. Can we work out something? You know, they're much more likely. The first step in collecting a debt is to get the debtor's attention. And when they get a legal letter by certified mail, they will respond promptly. Don't let it go. Keep up the pressure. Make a nuisance of yourself if necessary. I talk about this a lot in my video. The squeaky wheel is much more likely to get paid. And then consider filing a claim in small claims court. Okay. Last but not least, when and how to fire a client, then we'll take questions. Some clients are not worth having. You know, consider terminating. These are the people you got to get out of your life. Repeat offenders. You know, fool me once, shame on you. Fool me twice, shame on me. That's an old saying. Clients whose conduct suggests moral turpitude. If I think a client is doing something that's criminal, I want that person out of my life. I do not want to be associated with that person at all. Clients you would not accept an invitation to LinkedIn from. That's kind of a good way. We all have our criteria about who we let into our LinkedIn profile and who we don't. You know, use that as a nice judge. You know, if you wouldn't want them as a friend on Facebook, why are you doing business with them? Clients you don't like, I will tell you something. Sooner or later, when you dislike a client, it becomes a cancer. And if you don't get rid of the client, it can turn into malpractice, because your hatred, you start to take it out on the client by not doing the job that you were paid to do. And when that happens, you could end up finding yourself guilty of malpractice to a person that you cannot stand. And that's one of the worst things that can happen to any consultant. Clients that keep you awake at nights. If someone's really bothering you and you can't sleep at nights because of this person, again, trust your gut. Send a formal termination letter in writing, certified mail, return receipt requested. If the client owes you money, hold on to their files and other deliverables until you receive payment, unless your lawyer tells you can't. Those of you who are accountants, CPAs, there are very specific rules in your profession about when you can retain client files as security for a bill. Make sure you talk to an attorney and make sure you understand that rule. So, okay, I'm just going to deal with this, protecting against liability. You know, right now I think I want to start taking some questions here, so we're going to pass over this. Just know that I have a YouTube video on this as well. If you go to youtube.com, search for Cliff Ennico, Keeping Lawsuits at Bay is the title of it. Cliff Ennico, Keeping Lawsuits, and you'll see I do a whole hour on this exact topic. So, summary, don't try to be all things to all people. Trust your gut when taking on new clients. Get your contract language crystal clear, especially when you get paid. Communicate closely with your clients. Be friendly to your clients, but don't let them become friends. Bill early and often. Nip past due payments in the bud before they grow. And don't be afraid to terminate problems. Trust me, there is plenty of work out there. You do not have to work for people who don't know what they're doing and have no money. So with that, here's some of my best-selling books. The Small Business Survival Guide. I talk a lot about dealing with deadbeats in there. For those of you who sell stuff on eBay or Amazon, the eBay sellers, this is sort of the Bible on the legal and tax issues involved in that. And this is what I look like when I'm not doing SCORE webinars. So with that, I'm going to stop talking, and Bob, let's take a couple of questions that have.
Okay, thanks. We do have a minute or two for questions. The first one is from Phil. Cliff, I'm curious whether you warn prospective clients in advance that you don't want clients that do X, Y, and Z, or do you just deal with them when it becomes clear they are one of the problem client types?
Yeah, it's very hard to tell somebody, especially in an initial conversation. I really am worried that you're going to be a jerk, and this is why I'm doing it this way. I mean, it is kind of offensive to clients. I mean, I try to use my best judgment. I mean, when I'm doing an initial call with a potential client, I let them do 90% of the talking. I try to say as little as possible. I want to let them talk. If they talk enough, I'll be able to figure out if they're going to be a problem child or not. And sometimes, I mean, sometimes people do surprise you. The best way to deal with that. So, for example, for certain types of work, I do have a minimum fee. And that does turn some people off. They say, well, wait a minute, Cliff, if you're not earning it, why should I pay it? And what I do is I don't talk about them specifically, but I talk about the situation. I say, in my situation, these deals inevitably, even though they look simple and even though they look like they're going to go through very smoothly, things happen and things that we cannot predict. You know, for example, this could happen, this could happen, this could happen. Rather than bill low and give you an unpleasant surprise down the road, I've just learned that I always end up billing at least this amount. So I want to be very upfront about that. And if you're not happy about that, please go, and talk to other attorneys. Lord knows there's plenty of them out there. That way they get the message, but it's not directed to them, personally. I mean, some clients do not like to pay an upfront fee at all. They don't like the idea that they're paying a retainer. And I always make it clear, look, if I don't use it, you get it back. You call me up and, tell me, hey, Cliff, is there anything left over in the pot? And, if you're not going to use me for a while, I'll refund the excess to you. I'm ethically required to do that, by the way. I get in trouble if I don't do that. But that's the kind of thing that it's best. That's why I say, get money up front and just, protect yourself against especially the time vampire, the client that sucks a lot of time out of your life. And then all of a sudden, oops, the deal didn't happen. I can't pay you now. I was relying on the deal to close before I could pay you. Okay, that's something you want to flush out. I'm having a conversation right now with a client. It's a client that wants me to take on a very big deal. It's probably mission critical for their company, but they want me to work on spec, and it's probably going to be a $10,000, $15,000 job. And I'm saying, yeah, I mean, if the deal happens, I trust you. I'll get paid. I've worked with you in the past. I know you're a good person. I said, but you have to understand, if this deal doesn't close, where does that leave me? I don't want to own this company. I don't want to run this company. You can give me the stock, but I don't know what they do with it. That you have to have that kind of a conversation. And if it's a client that you've worked with before, it'll be easier because you have a way of communicating with that client. I try to use humor. I try to get them laughing, because once they laugh, then they get, the situation here. So anyway,
unfortunately, we're out of time. And so just a reminder that the webinar has been recorded and the materials will be available the next day or so on our website under on-demand webinars. And our next live webinar is tomorrow, March 22nd at noon. Topic is government contracting. Are you ready to receive government contracts, with Tanisha Baptiste and Stephen Samaya presenting. And again, if you would like to take advantage of free individual counseling, you could do so using the link on the screen, or you can go to our website and click on Request a Mentor. And on behalf of SCORE, I'd like to thank everyone for attending today's live webinar. And in closing, a big thank you to Cliff for presenting today. And thanks again, everyone, and enjoy the rest of your day. Thanks, Cliff.
You guys, take care.
Take care.